Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Good afternoon, and thank you for joining Mayor Brown's Global Financial Markets Initiative. Our topic today is Unresolved Issues with the Corporate Transparency Act. My name is Brad Resnikoff. I'm a partner in Mayor Brown's Litigation Regulatory Enforcement Group in our Washington, D.C. office, and joining me today is my partner, Matt Bisanz. Matt is a bank regulatory partner, also sitting with me in D.C. And there's a lot to talk about, Matt. I don't know about you. I'm probably overly excited about the Corporate Transparency Act and FinCEN's implementing regulations. You know, we're about a month away from the effective date of the rule. And we've given some of these talks before, both internally to clients, and on the string here, and I'd like to say that everybody's, been following it as closely as us and internalizing the things that we've been saying and getting ready to comply with this rule. But I'm not sure that that's the case. And so I think this is the perfect time for us to be discussing it. Just earlier today, FinCEN, in fact, finalized and formalized a little bit of an extension of time for the filing of beneficial ownership reports for reporting companies that are created after the effective date of the rule. So that's a nice little thing. And so really happy to be joining you today, Matt. And to kick things off, I'm going to give a few minutes of background on the CTA, on FinCEN's regs, and the impending effective date, and the things that every reporting company needs to do to comply. And we're going to go back and forth after that a little bit, Matt, to discuss some of the issues that folks are still contending with. So to start us off, I mean, this is a pretty big deal. I mean, for a variety of reasons. First, we don't often see in the AML space, huge pieces of legislation or regulation that really represent a substantial change. And in this case, we're really seeing something that's arguably maybe the most significant piece of legislation since the Patriot Act in the AML space. And so it's a big deal for that reason. It's a big deal also because an estimated 30 plus million legal entities are going to be subject to the requirements of the Corporate Transparency Act and FinCEN's regulations. So there's going to be broad effect across industries in a way that AML rules typically don't have such an impact. So in terms of scope, this is quite a difference to the current regime. Just very generally taking it from the top, what does the CTA do? What do the implementing regulations do? The rules require U.S. entities, including corporations and LLCs, and non-U.S. entities registered to do business in the United States, to register with FinCEN and to disclose to FinCEN the identity of ultimate beneficial owners, defined to include all individuals exercising substantial control over the entity or individuals with a 25% ownership interest. Now, the definition of beneficial owner, as stated, is quite broad, just like the rule itself, and intentionally so. Not only is it going to capture individuals with a financial interest with a 25% or greater ownership interest, but anybody with substantial control. And substantial control is another term that is broadly defined. It's going to capture a wide spectrum of persons by virtue of their title as senior managers, and also by virtue of what they in fact do, if they have influence over the significant decisions of the reporting company. And the information to be reported is also significant. It's very sensitive information. It's personal identification data that belongs to the beneficial owners. And this information is going to be stored by FinCEN in a centralized database and made available to law enforcement. It's also going to be made available to financial institutions who have CDD obligations to the extent that they obtain consent to access the information that is reported by their legal entity customers. And we've seen for several months now already, in the transactional space, reps, warranties, covenants, dealing with CTA compliance and with this consent issue, where lenders, for example, are looking to borrowers, in the context of a loan agreement, to provide the necessary consent so that the lender can access what will be reported. The taking a step back, this is a new federal legal requirement, and it's the first of its kind, right? Financial institutions since 2016, when FinCEN finalized the CDD rule, they've had to collect beneficial ownership information from certain legal entity customers. But the CTA creates new legal obligations for a broad array of U.S. and non-U.S. legal entities. As I said, FinCEN's expecting over 30 million legal entities to report within the first year. The purpose of the rule is really a money laundering enforcement. It's really to impede bad actors from abusing legal entities, from creating shell companies to conceal proceeds of corrupt and criminal acts by creating this single comprehensive source of beneficial ownership information. And it's not surprising, frankly, that this is happening now. I think, perhaps for decades we've seen versions of the CTA proposed on at the federal level, but they never made it very far. But the Biden administration and Biden himself, President Biden himself, has always had, I think as one of his main policy objectives rather, an interest in really clamping down on corruption and curbing corruption. And so I don't think it's surprising that it's his administration that finally got something like this through. And it also levels the United States up with the European Union and the UK, and where beneficial ownership information has been collected and in some cases made public, which is quite different than what the CTA proposes, but really where beneficial ownership information has been collected for many years. And so we're starting to come along with our colleagues in Europe. So I think I'll pause there, Matt, now that we've gone through a fair bit of the background. I should say, even though we're dealing with a very broad rule that's going to capture many different types of legal entities, there are exemptions, and I think we're going to talk about a few of them in particular today. And you've got some of the more common exemptions that you would expect for your banks and broker dealers and SEC reporting issuers, entities that are already subject to a significant supervision regulation. And then there's others that seem, at least at first blush, to be helpful. But as we've gone through the rule and the proposals, and with our clients, we've seen that these are actually fairly narrowly tailored, some of these other exemptions, and it makes it a little bit difficult to perhaps fit into one or more of them. So Matt, tell me, what are some of the issues that folks are still grappling with?
Thank you, Brad. Yeah, I think you're right that as we've dug into the 23 categories of exemptions, we have found out either that they are surprisingly narrow or surprisingly complex. That even something that sounds as simple as, say, the exemption for an insurance company, which is defined as any insurance company under Section 2 of the Investment Company Act. Now, I think probably you, like me, we have car insurance, homeowners insurance. We get a bill every year in the mail, and that to us is an insurance company. And if we named one, we'd probably pick an insurance company that really is an insurance company. But it turns out there is a diversity of insurance companies under Section 2 of the Investment Company Act, particularly when you get on in the offshore insurance space, when you're looking at different Bermuda license classifications. And so when we're thinking about clients or who are trying to figure out, well, do I qualify for this exemption or not? Well, yeah, if you're one of the five biggest insurance companies in the world, sure, you probably do. But if you are that mid-size or that small insurance company or that captive insurance company, now not only are you looking at the CTA and FinCEN's regulations, but you're also looking at the Investment Company Act and how has SEC staff interpreted the definition of insurance company in Section 2 and what are the different classes of insurance company. And so what starts off with, and to most people would seem like an obvious question of, well, is it an insurance company or not? It turns into this long searching exercise. And so those kind of questions around exemptions are something that is turning to be an unresolved issue. I also think there's been a lot of hand-wringing over the identification of persons who have substantial control over entities who are required to report, that unlike the CDD rule that you and I have been dealing with for several years, the new requirements say that all persons with substantial control must be reported, not just one person. And so while it might be easy to identify the named senior officers of a reporting company, when you start looking at, well, who has the power to make major decisions or direct major decisions, who can select a majority of the board, what happens if I'm using a contracted or shared employee versus an employee on my payroll, how does that interact with some of the exemptions we'll talk about, that those types of questions around substantial control are getting fairly knotty. And then I think lastly is going to be the operational nightmare, which I know we're going to touch on, but even as a law firm, that is something we are confronting.
That's a good point, Matt, in terms of the operational. It's really, this rule is really going to have to create, or rather reporting companies are going to have to create infrastructure to deal with it. This is, it's not a one-time thing. This is an ongoing legal requirement that is going to require reporting updates as changes occur with respect to beneficial ownership for a given reporting company. So that's a good point. Matt, you mentioned a couple of the exemptions that folks are finding a little bit challenging to understand. Are there others that you think our clients in particular would be interested in hearing a little bit more about, and some of the more contentious issues with respect to them?
So yeah, I think the one we've been hearing the most about, and I know you've worked on the spreadsheet that some of our clients are completing on it, has been around funds and other types of pooled investment vehicles. That in the regulation, there is a fairly obviously named pooled investment vehicle exemption, and it's defined as a pooled investment vehicle that's advised by certain types of financial entities. And as we know, when we look at the definition of pooled investment vehicle, it says it's either a fund under Section 3A of the Investment Company Act, or a fund that would be an investment company under that act, except for the exceptions in 3C1 or 3C7, and the fund is named on an investment advisor's Form ADV. And if you look at that, that's already a pretty complicated definition to understand. The whole idea of being an investment company under 3A, like that we'll get into it, but I think that one part is that, well, why would you say that instead of just saying a registered investment company? That for most fund lawyers, being an investment company under 3A is synonymous with being a registered investment company. But moreover, the whole idea of this being a excluded investment company under 3C1 or 3C7, like that's something a lot of us can understand. But the requirement that it be reported on a Form ADV has sent a number of our clients scurrying off to review their Form ADVs, talk to their investment advisors. I think one early idea was, well, why can't we just list all of our entities, even if there's, say, a tax blocker or some intermediate structure on there. And then people realize that would create securities law problems. And so that exclusion has its own problems to it. But there's also an inconsistency here that separate from this whole pooled investment vehicle exemption, there's another exemption for registered investment companies. And I think we spent a couple hours yesterday talking about, well, how is a registered investment company different from an investment company under 3A? And we were talking with our colleague Adam, who knows the 40 Act, and probably the best answer we came up with is, oh, well, maybe the reference to 3A means certain offshore funds that aren't registered because they're excluded from US law. And like, this isn't discussed anywhere in FinCEN's guidance. It's not discussed in the statute, but the only other reading would be that these two exemptions are duplicative of each other, and that like can't be the answer under a statute. So that whole scoping of the pooled investment vehicle exclusion, that's a difficult one. Another one we were discussing today, I know you were I think in a meeting, was around the Section 3C17 language that many funds rely on multiple exemptions from being an investment company. They may be a real estate fund, but also they're only sold to accredited investors, or they may be an operating company, but also they have fewer than 100 investors. So there's multiple grounds on which a company could rely. And when the statute says is an investment company or would be an investment company, but for Section 3C1 or 3C7, that's, well, is that the only exclusion you're relying on? Is that one of many? That you probably remember from the Volcker rule context that it was fine to tack together multiple exclusions. So a company could be a 3C5 fund and a 3C7 fund, and that would be okay. But we don't know if FinCEN will say that is okay for relying on the pooled investment vehicle exemption. Another one that has been really trying us has been this whole idea of a wholly owned subsidiary, that the proposal or the regulation helpfully has language saying that a subsidiary of certain types of exempt entities is itself exempt. And at first I thought, oh, this is going to be one of the easier ones for you and me to apply, that is it wholly owned or not? And then we had FinCEN statements of, well, we mean wholly owned in the narrow sense of the word, that if there's any kind of ownership interest, even if it's something like carried interest, equity kickers, director shares, that can be enough to disqualify you from the exemption. And so that was some bad news. But then I think we've also been hearing in the market around the other part of the statutory phrase where it says an entity that is controlled or wholly owned. People in the comment period raised the, well, that's a disjunctive, statutes have meaning, and so control must have a separate meaning from wholly owned. There must be some other grounds where you can be not wholly owned but controlled. And FinCEN seemed to say something along the lines of, well, we actually interpret control to mean wholly owned. It's not a model of clarity. I think some people have said, well, look, Congress meant control to mean something different. You can't say that it means the same thing when there's a disjunctive there. And so there's a lot of debate going on around, well, if you have a subsidiary that is controlled by a company but is not wholly owned by that company, is it an exempt subsidiary or not? I tend to think it's probably not, but I recognize there are multiple viewpoints here, and I think we'd probably be interested in hearing more about them. But yeah, that's the kind of stuff I've been hearing about the exemptions.
There certainly does seem to be a lot of nuance, Matt, with these exemptions, and because many of them, like the pooled investment vehicle exemption, cross-reference other bodies of law, I think one of the many good things about practicing in Mayor Brown is that we don't have to figure the stuff out alone, and we have experts in the fund world and the 40 Act world who can really help bring some of these trickier exemptions to life for us and for our clients. And so always appreciate that. Matt, you mentioned a little bit earlier that along the lines of this controlled or wholly owned, identifying persons to be reported, persons who exercise substantial control can be another thorny issue. Can you talk a little bit more about that?
Sure. So I think when we thought about beneficial owners in the past, we think about it in the context of economic exposure. May we all be so lucky to have a 25% or greater ownership interest in a company that is worth the government's time looking at. But the CTA and its implementing regulations take a broader view of including people who have substantial control, even if they don't have an economic interest in the company. And so first it says that all senior officers always are included as having substantial control. And it lists certain types of senior officers, like the general counsel, the chief executive officer, and then it says people who perform a similar function to these named senior officers. I don't know about you, but when I go on LinkedIn, I see some pretty creative titles with the word chief in them that really can't be important people in a company. And so that can't be the similar function as just having chief in your title. But also, like if I just name someone, the person who's responsible for pushing in the chairs, that doesn't matter. Like if they're the one who is making all the decisions, the title I give them doesn't really matter. And so FinCEN really has not provided guidance around what is a person who performs a similar function to one of the named categories of senior officer. And for larger companies or new companies with creative titles, I think that's an area that could use more clarity. Another one that doesn't really make sense is that when FinCEN talks about who has substantial control, it includes senior officers, it includes people who directly or who directly make major policy making decisions. It includes people who can control the appointment of a majority of the board of directors. It does not include individual directors unless they have substantial control through some other means. And again, it doesn't really make sense that the directors who select the senior officers are not persons with substantial control, but the senior officers are persons with substantial control. And I think we've had some clients even who have assumed the directors would have substantial control, and we've had the good news to tell them they probably don't. But that's one of those things that doesn't make a whole lot of sense. Another one that doesn't make a whole lot of sense is there's an exclusion for people who aren't senior officers, but are employees of a reporting company who are just acting within the course of their employment. And so while I'm sure you could have some kind of mid-level manager who is exercising substantial control, and it is pursuant to some broader concept of their role in the company, and so therefore they are considered a person with substantial control. I wonder if, like, could you say that it's just always going to cancel out the definition of substantial control, that if you are an employee of the company and you just have a paycheck coming from the company, that you never will be a person with substantial control? That seems too easy to me, and probably FinCEN would think so, but that's an area. The other one is the exemption says that you're only excluded if you are an employee of the reporting company acting as an employee. But as you and I know, a lot of our clients are these large global organizations with hundreds of subsidiaries, and they may have employees based only in one or two of the entities for paperwork purposes, but those employees are shared with all of the other hundreds of companies in the group. And so they're technically not an employee of the reporting company. They might be an independent contractor, they might be an agent, but they're not an employee. And so do they lose the benefit of the employee exclusion solely because they happen to be employed by an affiliate? That again, that feels a little inappropriately narrow, if you ask me. The final one, just because I'm ranting on these things, is there's really no guidance provided on how to treat individuals who have actual authority to exercise substantial control, but don't, as a practical matter, exercise it. And one good example is again, in these large groups of companies, you have the CEO, some person who sits at the top of a pyramid of 100,000 employees and 1,000 legal entities, and in theory, that CEO could make decisions for any of those 1,000 entities. Now, as a practical matter, she or he probably doesn't, that they're the CEO of a huge organization, so they're not going to make decisions for every little SPV in it. And so while in theory they could, they don't. But can we say that person doesn't have substantial control because they don't exercise that authority? I tend to think yes, but again, it's not really addressed. Conversely, you might have fairly low-level people in an organization who do have the hallmarks of substantial control. Like they could open or close a company's bank account. They could sign major contracts under a delegation of authority. They don't, because they know that that's not their role in the company, but they might be empowered under an SPV's articles of organization to make those major decisions. And so just is the fact that they're empowered to make it enough if their role would not otherwise permit them to, that, and I tend to think they shouldn't be seen as persons with substantial control if they're just the clerk opening bank accounts for SPVs, but maybe FinCEN thinks otherwise.
Yeah, it's tricky. These are all, very interesting, nuanced points. I mean, I think we should give some credit to FinCEN. They've put out, several pieces of guidance. They've provided practical, sort of real world examples in their proposals, in the preambles to these rulemakings. And it's unfair for to expect them to cover off every single one of these sort of nuanced or complex issues, on the issue of substantial control and other issues under the rule. I will say it's interesting. When you started off, you mentioned, of course, that it's not about finding one person who exercises substantial control. It's about finding anybody who exercises substantial control, right? FinCEN wants you to report all of these people, and by defining substantial control in these different ways, by including a de jure definition based on somebody's role or title, and by providing examples of persons who in fact exercise substantial control, and explaining what that means to some extent. I mean, it does seem like, again, as they did with the definition of reporting company, as they did with the definition of beneficial owner, it seems again that here substantial control is another very broad concept, and it is going to be a challenge, as you said, indeed, for these very large groups. I didn't mention it at the outset, but maybe we can switch gears for a few moments here, Matt, and talk about company applicants. These are other individuals who are going to be subject to reporting under the CTA and the FinCEN regulations. Can you talk to us a little bit about the definition of company applicants and issues that you've seen in the market relating to the reporting of them?
Yeah. So yeah, you're right, Brad, that it is a little, I say, simpler, that there can only be one or two company applicants, and they're the individuals who either directly form the reporting company or who directed the formation of it. I know we're grappling with it as a law firm because we obviously help clients form legal entities, and there are all sorts of questions over, well, is our corporate services provider, is that employee going to be it? Is someone within the law firm it? Is someone at the client? the company applicant, but maybe I'll put those aside for today because they've been getting a lot of air time, and instead I'll focus on the ways in which company applicants are really going to be one of the more onerous parts of reporting. And so when FinCEN opens up the beneficial owner reporting system, they call it BOSS, on January 1st, we don't know what it looks like, but we know it will be opened. They have said that you have to file the beneficial ownership information of each of the company applicants in there. That's things like name, date of birth. For a company applicant, it can be a business address, government ID number like a driver's license, and then an image of the driver's license. Or you can get a FinCEN identifier number from that person if they've gotten one from FinCEN. And if they've gotten a FinCEN identifier, I think it makes sense. You just type in the identifier and you go on your merry way. But if you go down the other road of getting that information from them and you key it in and you upload the image of the driver's license, that's good, but not really going to work, because let's say in 6 months, you have a change in executive officers of the reporting company, and you go back into FinCEN to file an updated beneficial ownership report, and it asks you to provide information on the company applicants. And so now you have to go back through your email from 6 months ago and hope that you have the name, date of birth, driver's license number, business address of that company applicant who, let's say it was a law firm who formed your company for you and it was a paralegal at that law firm. Probably, again, don't really remember who they are because you dealt with them 6 months ago to form a subsidiary. But you find the email and you key it in, and then you go by another 6 months, you have more executive officers change, and you go back to every time uploading the image of the driver's license, and then you realize, oh wait, the driver's license has expired. Now it's no longer a valid identification document. I have to go back to the law firm that formed this and hope the paralegal will give me a new driver's license for them. And so that's why I think we've been encouraging a lot of people to go the FinCEN identifier route, because then you don't have to keep track of all of that beneficial ownership information and keep track of the expiration date on the identifying document, because it just is going to be impractical in the long run to do that for company applicants.
Matt, can you talk a little bit more about the setup of BOSS and perhaps some other challenges that we've been encountering?
Sure. I know we haven't seen the interface yet because FinCEN has been keeping it a closely guarded secret, but we did look at the system of record notice that they were required to publish in the Federal Register. I think we've been talking to people. You and I have experience from filing suspicious activity reports with FinCEN, so we know how they think about records systems. And there are some parts of it that seem like they're going to be problematic. One relates to the transferability of information. And so let's say I create an account on BOSS, I log in, I submit information on a reporting company, and then I want to have someone else submit that information going forward. That I'm only doing the initial filing, someone else will take over the obligations to update it. My read of the SORN is that BOSS will not allow me to transfer what I filed to a new person. That when a new person logs in, they will be able to file a new beneficial ownership report for the company, but they won't be able to see what I filed in the past. And so they'll kind of be filing blind if I haven't given them a copy of the record. And it's not even clear that I could access it, but it seems more clear in the SORN that there's no way for me to transfer or delegate or that kind of group user functions on companies. And so that I think will be a problem when you start, if you have companies doing it on their own, because you're going to be counting on the person who made the first filing to either keep really good records or never leave the company. That's another reason why, at least I've been pushing the vendor route, because if you have a vendor sitting between you and BOSS, the vendor will keep far better records and be able to show you every time what was filed, because they're in the business of keeping records, whereas FinCEN, as on many occasions says, it doesn't consider itself to be a record keeper for the public. It's just creating databases for law enforcement. So I think that's the kind of thing that makes BOSS challenging for corporate users.
Thanks, Matt. One thing we haven't talked about yet is perhaps some of the privacy aspects associated with the CTA, and in particular, the fact that we're talking here about the most sensitive possible information. This is people's identity and their association with a specific legal entities. And as you mentioned earlier, when you're dealing with large multinational corporations or groups that operate across borders, as many of our clients do, you may well have a non-U.S. person sitting somewhere abroad that is going to be subject to disclosure, who's going to be identified as a beneficial owner, and whose identity is going to be is going to have to be reported pursuant to this new legal obligation. And I imagine, Matt, that some of our clients have been raising this very issue and sort of the uneven nature of the data privacy regimes here and elsewhere in the world. Can you talk a little bit about the privacy issues that you've seen come up so far?
Sure, I'd be happy to. So yeah, in the U.S., I think we're less sensitive to these issues than we probably should be. But if the government asks us for information, we generally have to provide it. That is not the way it is in many other parts of the world. And so if you go to pick your European country and tell them you must provide the US government with information on this European company that you own because the European company has registered to do business in New York, or maybe the European company owns a US company that is itself a reporting company, you're going to get a lot of people who are saying, no, that is my right to privacy. There's no basis for the US government to do it. I have my GDPR or other national privacy laws. And FinCEN has been fairly uncompromising on this, that there is no recognition of foreign privacy laws in the CTA regulations. There's no understanding that some people may refuse to provide this information, that it may be unlawful for a company to ask for this information. That I don't practice law in Europe, but I've heard that under some European employment laws, you can't even ask your employees to consent to disclosing their information in this way, because that's considered inherently coercive, since they're your employees. And so if you're telling a company, well, your US obligation is to get this information on your employees, but your European law obligation is to not even ask them for it, that's putting companies in a hard place. The other part to this is that FinCEN has, even in the most recent versions of the reporting form, said that they're not providing any way for a reporting company to partially comply. That putting aside foreign privacy law, there's just going to be some companies who can't get ownership information. You'll have uncooperative owners. You'll have owners who maybe can't be reached. You'll have owners who, if you're not sure if they're an owner or not, because again, stock is transferable in many cases. And originally, FinCEN was going to put in checkboxes saying unknown information or couldn't obtain. And in the most recent statement, FinCEN has said we got rid of those checkboxes. You must submit all information on all beneficial owners. We might, at a future date, consider drop-down menus allowing you to explain why you haven't yet obtained the information. But this is a fairly rigid approach that just doesn't recognize the practicalities that even in the best systems, there will be people who, for one reason or another, refuse to provide information. I think there will be some people who are rightly concerned with data protection concerns of FinCEN is creating this massive database that will be accessible by pretty much all of federal law enforcement, many state law enforcement, and if it's hacked, what's going to happen? If people's driver's license is compromised, if their date of birth is put out there and sold, what kinds of protections will there be for them against the government? And so I think we should expect a significant level of pushback from many of the individuals who are contacted by reporting companies.
Well, Matt, it's crunch time. It's crunch time. January 1, 2024. That's the effective date of the reporting rule. You've got 90 days for entities formed after January 1, 2024 to come into compliance. That's only going to be 90 days for the first year. After the first year, I believe it reverts back to 30 days, which was what was originally in the rule. So we're getting a little bit of a reprieve, a little more time to figure this out. And of course, pre-existing entities will have a year to come into compliance. But now's the time. If folks haven't been thinking about it, this hasn't come across your radar. As I think our discussion today has illustrated, there's quite a few issues to work through, particularly if you're a part of an organization that operates across borders or has just a lot of entities and complexity to your corporate structure. So, Matt, thank you. Really enjoyed our conversation today, and thanks to everybody who's listening. Really grateful for your time. If you have any questions about our podcast today or anything else related to global financial markets, please do email us at gfm@mayorbrown.com. And take care.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.